Braxton Hughes, and this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or?
All right, pause right here. This case already has a ceiling. A 4-year cap means no matter how bad things sound today, the judge legally cannot go above that. But don't get it twisted, the judge still decides where inside that range this lands. And that pre-sentence report? That's the real silent killer in sentencing.
Correction.
Another word, Judge.
Judge, obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I defer to whatever he thinks.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, this is, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but they were getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. He walks in, gets him something to drink.
This is a classic defense move. He stayed. He waited. He cooperated. But here's the problem, intent doesn't erase impact. Walking into the wrong house while high might sound accidental, but to the person inside? That's pure terror.
It has a thermos or something like that, and then turns around and she's standing there. He had obviously scared her, and and didn't know it, and it wasn't the person he knew that lived there, and he said call the cops, and he walked outside and sat down and waited for the cops to show up, and that's what happened. It's not like he was going in there to try to injure her. I don't think he walked in the wrong house, and he did take the thermos or mug, and it's as simple as that. I think he'd like to talk to the court, Judge, and we're asking for probation, Judge.
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about a year and a half, but I was like a lightweight. I took the drugs and was not really acting like myself, and I went and knocked on the door and went in there. I was trying to get away from the people I was with.
Oof, that right there is the moment the courtroom temperature drops. When a judge says your record tells a different story, your credibility just took a direct hit. In sentencing, patterns matter more than promises.
But long story short, after this event, I did sober up, started going back to church with my mom. I was in for treatment at the Right Step. I tried to get in the treatment there. I was doing the paperwork, trying to get help, but I was sober for a couple months out there on the streets. And
let's translate this: multiple misdemeanors, multiple felonies, and repeated arrests that didn't even make it to conviction. Judges don't just count convictions, they read the entire behavioral pattern. And this pattern? It screams risk.
I'm not really like a typical druggy type. I don't go around commit crimes or nothing like that. I was.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things, because you've been a criminal since 2002. You've got 1, 2, 3, 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. Most of my previous crimes and stuff, they were behind addiction and stuff. But life's a journey, and I haven't, you know, I'm still was battling with addiction, but not committing crimes. You know, so that.
And that's the nail in the coffin. Probation is about trust, and this record shows every chance was burned. Once a judge hears every probation revoked, incarceration becomes the default, not the exception.
This, I know, with the standing here in front of you, you know, charged with a crime, I could understand, you know, how it sounds.
Yeah, I mean, and it's at what point do you go get that help before you commit a crime? You know, I do appreciate your
4 years. Not the maximum, but absolutely not mercy either. This is the court saying, we gave you chances. Now we protect the public. And watch closely, because the next defendant is walking into a much steeper legal minefield.
what you've done since the offense, Ms. Malfino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, or to whatever you think is best.
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation. And so
completing the last one.
Huh?
I did complete the last one.
The last one that I see was the federal
Yes.
sentence where your supervised release got revoked.
I did get revocation, but I got back out on probation and completed it.
Okay. At this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. All right, you can go back with the bailiff. And this is Miss Malfino. Good morning. Are you Leonard Guillory?
Yes, ma'am.
And so, Mr. Guillory, let's start with cause number 25. Is it printing? Hold on, I can't. Yeah, there it goes. All right, in cause number 25, DCCR 0902, you're charged with aggravated assault with a deadly weapon from June 19th of 2025. The indictment alleges that you were previously convicted of a felony offense, which means for punishment purposes, if you were found guilty, you would be considered a first-degree enhanced, and the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would run at the same time as a 10-year term in that motion to revoke your probation case. You have every right to reject this offer and have this case set for trial. I do want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer and have that case set for trial? So what we're going to do now, Mr. Guillory, is go through that motion. I'm going to get pleas of true or not true on that motion, and then we'll have a hearing on that motion first at a later date. I'll make a decision on that motion, and then we can go forward with your trial after that. Okay? So will he waive the formal reading of the motion?
He does, Judge.
In cause number 22-40982, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2024 for unlawful possession of a firearm by a felon, a third-degree felony, and that was a 7-year deferred probation. Is that correct? Speak up, please.
Yes, ma'am.
Thank you. And it alleges that you violated your probation. Count 1 alleges that you committed the offense of burglary of a vehicle June 8th of 2025 in Hardin County, Texas. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 2 alleges that you failed to immediately report the arrest from June 8th, 2025 to your probation officer. Is that true or not true?
Not true.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of participating in an education program for your GED. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the Moral Recognition Therapy, the MRT program.
True.
Count 6 alleges that you failed to pay your court-assessed fees as directed, and as of June 16th, 2025, you were $1,140 behind. Is that true or not true?
True.
And then it says second amended, but it never said first amended, so I think it's probably what we were all thinking it was. Anyway, count 7 alleges that you committed the offense of aggravated assault with a deadly weapon June 19th of 2025, and is that true or not true?
Not true.
Count 8 alleges that you committed the offense of evading arrest or detention with the use of a vehicle June 19th of 2025. Is that true or not true?
Not true.
Count 9 alleges that you possessed a firearm on June 19th of 2025 in violation of your deferred adjudication order. Is that true or not true? So did you enter your plea of true to count 6 freely and voluntarily? All right, then I'm going to find that count true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'll reset it for a hearing and ask the probation department to do an updated report. Mr. Coleman, does the state anticipate witnesses with regard to those the offenses that are alleged?
At least a couple of witnesses.
So we'll set it on a date when we're not in trial, not a docket date, so that we have time to have that hearing. All right? You can go back with the bailiff.